So wrapping up, in terms of the lessons to take away from today, first thing we want to remember is that the transitional provisions aren't a blanket security. It's not a matter of, hey, look, let's just sit back, it's going to come in place in January next year, we'll deal with it then. It's alive and kicking, and it has been for the last 16 months. I might have transitional protection. I probably do have transitional protection if I had an agreement that predated 30 January. And transitional provisions are likely to apply to me there. However, I'm still going to have a fight from a liquidator, most likely. So if I register, I'm going to avoid that fight. And if I haven't registered, what we want to remember is we're not just going to roll over when a liquidator tells us our security interest is no good. We want to work out whether our claim to rely on the transitional provisions can stick. It's not a blanket safety net. Second thing we want to remember is if a liquidator or administrator or receiver is appointed, we want to act really quickly. Things move really quickly in an insolvency scenario. And a couple of the rights that we talked about that are impacted here, one, if I've got goods that might become a fixture, I might have goods that are going to become commingled, or there might be proceeds that are coming in. The quicker I can act, the higher my chances of getting some money back. Remember the client that we looked after about a month ago, where if they hadn't gotten on the front foot and picked up the phone and talked to us within an hour of the administrators being appointed, or them finding out about it, their sinks and their ovens that we were able to get back for them would have been a kitchen in someone's high-rise. So there would have been a $100,000 write-off. Acting quickly potentially saved that client $100,000. We also want to make sure our credit apps cover these allocation and reallocation of proceeds. PMSIs are great. I can get this super priority. That's a really big, important win I have as a trade creditor. However, it's only any good to me if I can point to goods and show that they haven't been paid for. If I want to be able to get the most out of my claim, I want to have these allocation and reallocation of proceeds clauses in my agreement so that I can maximise that return. Similarly, it feeds into the fact that getting these terms and conditions of trade redrafted is crucial. And if they've been redrafted, we want to make sure we're picking up on all the lessons and getting the best value out of the experiences of the last 18 months. We want to make sure we're updating them to make sure that we're getting the best rights that are available to us. Also, risk assessments can help as well. The fundamental thing is getting the terms done up, but if we want to be really proactive and think about avoiding risks that we can't see right in front of us, looking at how PPS applies in the context of our business as a whole can be a really good way of covering over risks that just aren't apparent to us on the face of it. Proofs of debt. Just remember this big red flashing light when we see a proof of debt, because it might mean that you're giving up your security interests. So we need to estimate or not lodge a proof of debt if we're going to retain our rights. And if in doubt, just pick up the phone. Give one of our guys a call. It'll take less than 5 minutes, and let's work out what we need to do to make sure you're protected. Preference claims, none of us like them. We all think they're a rip-off. We've now got a little bit of extra protection there. We can potentially have a defence if we've got our PPS rights in order, and also it gives us an opportunity to make the liquidators do some more work to see if we can make them go away altogether, or at least put us in a spot to cut a good deal early. Stock take. We need a stock take. It's up to us. We have to protect our own interests. If I'm going to rely on a PMSI, I need to be able to point to that stock, and I need to be able to reconcile it back. If I want to stop my stock becoming a fixture, I need to be able to show that it actually was stock as at the date of the administrator's appointment. I can't just assume that the liquidator or receiver is going to help me. So I want to get that stock take done as soon as possible. The other obvious thing is, if you're a skeptic, it wouldn't take much to work out why liquidators, receivers regularly say no when we want to take our goods back. So what we want to do is just make sure that our interests are being protected. WOW, again, was a classic example of that. In that situation, we talked to so many creditors on the way through that had really good claims, and they went, oh look, this is getting a bit hard, I don't want to spend any money, I'm going to walk away from my claim. So going back to WOW, that was a classic example. People literally walked away from millions of dollars of claims. So money that should have been in trade creditors' pockets went into the receiver's pocket and the bank's pocket because they didn't have the tenacity or didn't have the confidence in their advice to be able to stand up for their position. It was those creditors like our clients who said, you know what, I think that's nonsense and I'm not going to roll over here, they're the ones that walked away with money in their pockets. And finally, getting someone to help you out who specialises. This legislation, the Corporations Act on its own is a nightmare. Throw PPS on top of it and it's a complete minefield. There's been some winners in the last 18 months and there's been some losers. The winners are the ones that have actually gone in there, haven't taken no for an answer and made sure they've gotten the right advice on the way through. The losers are the ones that have generally either looked after themselves, walked away from their claims, or gone to a generalist who doesn't specialise in the area. So making sure that you're in the best possible position is how you end up with money in your pocket. In terms of wrapping up for today, what we were trying to do is draw on some experiences of the last 16 odd months and trying to give you guys some practical tools that you can go away, look at the experiences we've had and take away and apply in your businesses to try and avoid some unnecessary losses. I hope there's at least one or two good things you can take away today and do that. Thank you.